All right, guys. Okay, so we're just going to go through this. We'll start with the notice. So Wayfarer have filed a notice of motion and a memorandum and a declaration to dismiss the eighth cause of action, which is a defamation cause of action, against John Doe defendants, right? So this is not for any of themselves, any of the parties. It's not for Jen Abel, Wayfarer, Justin Baldoni, or Melissa Nathan. This is specifically, so there is a cause of action for defamation, and it is only against John Doe defendants, and it has been since this complaint started, basically. However, when Stephanie Jones attempted to earlier this year to amend her complaint, she did try to substitute Melissa Nathan as one of the John Does and bring an action for defamation against Melissa Nathan. She was also trying to insert Jamie Heath as well, because in his deposition, Jamie Heath admitted to recording a phone call, I think it was, between himself and Stephanie Jones. So she tried to bring in something about that, possibly wiretapping. Judge Lyman denied Stephanie Jones permission to amend her complaint. So we are here today, and basically Stephanie Jones, back in July, Stephanie Jones agreed to dismiss, withdraw the eighth cause of action for defamation against the John Does, and I'm assuming by this motion that she has still not done that. So we haven't seen anything on the docket to suggest she's done it. So here we are. So let's go through the very brief notice, and then we'll go through the memorandum and declaration. Okay, please take notice that the Wayfarer parties, by and through their undersigned counsel, move this court, the Honourable Judge Lewis Lyman, for an order: A, dismissing the eighth cause of action for defamation against defendants John Doe 1 through 10 with prejudice pursuant to Federal Rules of Civil Procedure 41B, or B, in the alternative, dismissing the eighth cause of action for defamation against defendants John Doe's 1 through 10 without prejudice pursuant to Federal Rules of Civil Procedure Rules 21 or 4M. Okay. This motion is based upon the accompanying memorandum of law in support of the Wayfarer parties' motion to dismiss the eighth cause of action, declaration of Ellen Garofalo, in support of the memorandum of law in support of the Wayfarer parties' motion to dismiss the eighth cause of action and all prior proceedings in this action. Okay, let's look at the memorandum. Just trying to find it. This isn't actually on Court Listener, so I've had to go to Pacer for this. So it's just it takes a little longer because I'm having to sign in. It takes a little longer just to navigate. Okay, so memorandum of law. This is not a long memorandum. It's only about 10 pages of substantive reading, because it's limited. Okay. So, introduction. So, the Wayfarer parties here is Wayfarer Studios, Justin Baldoni, Jennifer Abel, and Melissa Nathan respectfully submit this memorandum in support of their motion to dismiss the John Doe defendants and the eighth cause of action for defamation, which is directed solely against John Doe's 1 through 10, pursuant to Rules 41B, 21, and 4M of the Federal Rules of Civil Procedure and the Court's inherent authority to dismiss for failure to prosecute. The John Doe defendants and the eighth cause of action should be dismissed with prejudice. So remember, with prejudice means you cannot bring it back. That's it. It's done forever. Without means that you can, refile, take it to a different court, etc., etc. The John Doe defendants and the eighth cause of action should be dismissed with prejudice because plaintiffs Jonesworks and Stephanie Jones have failed to identify, name, or serve any Doe defendant, despite more than 19 months having elapsed since this action commenced, 15 months since the court-ordered deadline to amend the complaint, and 9 months since fact discovery closed. This is an entirely reasonable request. I think Lyman will give it. I do. Whether he does it with prejudice or without, I don't know, but I think he will. Okay. You'll probably do it with prejudice actually as well, because defamation is now completely time barred. It was when Stephanie Jones tried to amend her complaint to bring Melissa Nathan in as one of the John Does. That was part of the reason it was denied, was because the defamation claim was time barred. So there's no reason to deny it really without prejudice, because Stephanie Jones can't bring it back anyway, anywhere. Okay. Plaintiff's sole attempt to cure the deficiency, a motion to amend the complaint to substitute a named defendant on the 8th cause of action, was denied by this court's opinion and order dated March 26, 2026, for lack of diligence, undue delay, prejudice, and futility. The court found the defamation claim time barred. After that ruling, plaintiffs agreed to dismiss the 8th cause of action and the Doe defendants no later than July 10th, 2026. Plaintiffs broke that promise. Well, there's a fucking surprise. Plaintiffs broke that promise, failing to file the agreed dismissal and leaving the Wayfarer parties to seek the relief plaintiffs promised to provide voluntarily. The 8th cause of action is now legal nullity. It asserts a time-barred defamation claim against unnamed and unserved parties whom plaintiffs have failed to identify despite the court-ordered amendment deadline, the close of fact discovery, and the agreed dismissal date. Allowing the claim to remain on the docket serves no legitimate adjudicative purpose and imposes concrete prejudice on the Wayfarer parties by preserving the prospect of renewed discovery and continued defence of a claim that the court has already found futile. Accordingly, the court should dismiss the 8th cause of action with prejudice under Rule 41B and its inherent authority, drop the Doe defendants under Rule 21, or dismiss the claim and the Doe defendants without prejudice under Rule 4M. Statement of facts. Plaintiffs Stephanie Jones and Jonesworks commenced this action in New York Supreme Court on December 24, 2024. The complaint names as defendants Jennifer Abel, Melissa Nathan, Justin Baldoni, Wayfarer Studios, and Does 1 through 10. The action was removed to this court on January 27, 2025. The 8th cause of action, titled Defamation against defendants John Doe 1 through 10, alleges that unknown individuals created and published 2 websites that allegedly contain false and defamatory statements about the Jones parties, as well as subsequent disparaging social media accounts. The defamation claim is stated solely against John Doe 1 through 10, and no named defendant is alleged to be liable for the 8th cause of action. This court's initial case management plan and scheduling order set April 18, 2025 as the deadline to move to amend or join additional parties. Fact discovery proceeded and closed on September 30th, 2025, except for certain depositions pursuant to stipulation and order, without plaintiffs identifying or serving any John Doe defendant. Subpoenas were issued, but failed to yield the identity of any Doe defendant. On December 8th, 2025, nearly 8 months after the amendment deadline, plaintiffs moved for leave to amend the complaint to, among other things, substitute a single defendant, Melissa Nathan, for the Doe defendants in the 8th cause of action. By opinion and order dated March 26, 2026, this court denied the motion in its entirety. The court found that plaintiffs failed to demonstrate good cause under Rule 16b for the untimely amendment, exhibited undue delay, and a lack of diligence in pursuing the identities of the Doe defendants. It further found that the amendment would cause undue prejudice and that the proposed defamation claim would be futile because it was time-barred under the 1-year statute of limitations applicable to defamation claims. Notably, The court found that the plaintiffs did not request documents relating to the allegedly defamatory websites in their initial document requests served on March 6, 2025, and did not propound website-related discovery until July 2025, which was after the one-year limitation period had already expired. On April 14, 2026, the Wayfarer parties asked plaintiffs to dismiss their eighth cause of action given the court's amendment order and plaintiffs' failure to serve any Doe defendant. On June 29, 2026, plaintiffs finally agreed to dismiss the eighth cause of action for defamation and the Doe defendants by no later than July 10, 2026. Although the agreement was confirmed in writing, plaintiffs reneged on their commitment and have not filed the promised dismissal, requiring the Wayfarer parties to file this motion. The eighth cause of action and the John Doe defendants should be dismissed. Rule 41B supplies authority to dismiss the eighth cause of action with prejudice for failure to prosecute. Rule 21 provides an independent procedural mechanism to drop the Doe defendants, and Rule 4M requires dismissal without prejudice when a defendant has not been timely served, absent good cause, or a justified extension. The court also has inherent authority to dismiss for failure to prosecute. Because the Doe defendants have never been identified or served, and the eighth cause of action is the only claim asserted against them, these authorities permit the court to dismiss the eighth cause of action. Dismissal with prejudice is warranted under Rule 41B. Rule 41B of the Federal Rules of Civil Procedure provides that a court may, in its discretion, dismiss an action or claim based on a plaintiff's failure to prosecute or comply with the federal rules or a court order. Courts routinely dismiss claims asserted against Doe defendants for failure to prosecute pursuant to Rule 41B. In considering whether dismissal of a claim for failure to prosecute with prejudice is warranted, a district court considers the following non-exclusive factors, none of which is dispositive. 1. The duration of the plaintiff's failure to comply with the court order. 2. Whether the plaintiff was on notice that failure to comply would result in dismissal. 3. Whether the defendants are likely to be prejudiced by further delay. 4. The balance between the court's interest in managing its docket and the plaintiff's interest in receiving a fair chance to be heard. And 5. Whether the court has adequately considered a sanction less drastic than dismissal. These factors strongly support dismissal of plaintiff's eighth cause of action with prejudice. Plaintiffs failed to prosecute the eighth cause of action for more than 19 months from the commencement of this action on December 24, 2024, through the filing of this motion on August 13th. They neither identified nor served any Doe defendant during that period. District courts in the Second Circuit have found delays of 6 to 10 months sufficient to support dismissal. A delay of more than 19 months far exceeds delays that courts have found sufficient for dismissal and supports a presumption of prejudice. Moreover, the prejudice is concrete. The Wayfarer parties have litigated through the close of fact discovery and face the continuing burden, expense, and uncertainty of defending a claim that plaintiffs have not pursued and that the court has already found futile. Keeping the claim alive would also risk renewed discovery and further delay despite the expired limitations period. Significantly, plaintiffs refused to withdraw their expert Brian Horton, whose sole purpose is to testify regarding the alleged creators of the Jones websites, which are relevant only to the eighth cause of action. Further, plaintiffs refused to withdraw their damages experts' opinions and testimony arising from alleged harm caused by the alleged defamation asserted in the eighth cause of action, including the alleged defamation based on the Jones websites. Plaintiffs had actual and repeated notice that their failure to identify and serve the DOE defendants comply with the amendment deadline and resolve the eighth cause of action could result in dismissal. The court's case management plan and scheduling order required any motion to amend or join additional parties by April 18, 2025. The Wayfarer parties warned plaintiffs that the eighth cause of action and DOE defendants would be subject to a dismissal motion. Plaintiffs then agreed on June 29, 2026 to dismiss the claim and DOE defendants by July 10, 2026. That commitment gave plaintiffs actual notice of the precise relief at issue and defeats any claim of surprise. Plaintiffs nevertheless failed to file the agreed dismissal. Under the fourth factor, plaintiffs' interest in a fair chance to be heard no longer warrants preserving this claim. Under the fifth factor, no lesser sanction would cure this defect or achieve a just result. The court has already found that plaintiffs did not demonstrate diligence before the April 18, 2025 amendment deadline to identify DOE defendants. Plaintiffs did not request documents relating to the allegedly defamatory websites in their initial document requests served on March 6, 2025, and did not propound website-related discovery until July 2025, after the limitations period had already expired. Significantly, the court had already found that the eighth cause of action is time-barred, and that any further attempt to amend the pleading to identify DOE defendants would be futile. That finding is the law of the case. Rule 15C1A permits relation back only if the applicable state law standard permits it. New York CPLR Section 1024 requires diligence in attempting to identify a John Doe defendant. Plaintiffs cannot use relation back to evade the court's finding that they did not exercise that diligence and that the proposed amendment was futile. Dismissal with prejudice is therefore is warranted, as it deprives plaintiffs of nothing. Because 1. The statute of limitations on the eighth cause of action expired, 2. Plaintiffs cannot satisfy the diligence requirement for relation back, and 3. This court has already made those findings, the eighth cause of action is futile as a matter of law and should be dismissed with prejudice. Absolutely fair. And I do think, I find it hard to say these words, I do think Lyman will agree with Wayfarer. Okay. I find that he's not quite so willing to give in and give Stephanie Jones everything she wants as he was with Lively. So, yeah. This case should be interesting as we go into summary judgments, judgment on pleadings, etc., if there are any of those motions filed. Okay, alternatively, the court should drop the unidentified DOE defendants under Rule 21 and dismiss the sole claim against them. Rule 21 provides that on motion or on its own, the court may at any time on just terms add or drop a party. Although titled misjoinder and non-joinder of parties, Rule 21 is not confined to correcting technical joinder defects. Rather, it affords courts broad discretion to shape litigation in the interests of efficiency and justice, guided by principles of fundamental fairness and judicial efficiency. Once plaintiffs have had an opportunity through discovery to learn the identities of unknown DOE defendants but failed to identify or serve them, dismissal under Rule 21 is appropriate. Dismissal is also warranted under Rule 4M. Federal Rule of Civil Procedure 4M provides that if a defendant is not served within 90 days after the complaint is filed, the court, on motion or on its own after notice to the plaintiff, must dismiss the action without prejudice against that defendant or order that service to be made within a specified time. Rule 4M applies to John Doe defendants. A court may extend the time for service, but dismissal is warranted when the plaintiff cannot show good cause or otherwise justify an extension. Plaintiffs cannot show good cause or justify an extension. They had more than 19 months to identify and serve the Doe defendants, missed the April 18, 2025 amendment deadline, pursued website-related discovery only after the limitations period expired, completed fact discovery without identifying a Doe defendant, and agreed in writing to dismiss the claim and Doe defendants by July 10, 2026, but did not do so. Dismissal without prejudice under Rule 21 or Rule 4M is therefore warranted as an alternative to dismissal with prejudice under Rule 41B. Conclusion. For the foregoing reasons, the Wayfarer parties respectfully request that the court enter an order 1. Dismissing plaintiff's 8th cause of action for defamation against John Doe's 1 through 10 with prejudice under Federal Rule of Civil Procedure 41B. 2. Dropping the Doe defendants from the action under Rule 21. 3. Dismissing the 8th cause of action pursuant to the court's inherent authority, or alternatively, 4. Dismissing the 8th cause of action and the John Doe defendants without prejudice under Rule 4M. Okay, and that's from Ellen. Okay, let's check out her declaration next. Okay, so we've got a declaration, and we have a couple of exhibits as well. Or I don't know if there's a couple. There's an exhibit anyway, at least. I thought I saw 2. We'll have a look. Okay, so declaration of Ellen. I'm a partner with the law firm Liner Friedman. Attorneys for Jennifer Abel, Melissa Nathan, Justin Baldoni, and Wayfarer Studios. On April 14th, 2026, the Wayfarer parties asked plaintiff by email to dismiss their 8th cause of action, given the court's amendment order and plaintiff's failure to serve any of the Doe defendants. A true and correct copy of an email from my partner, Amir Kaltgrad, to Kristen Thaler and Morgan Anastasio of Quinn Emanuel and others dated for April 14th, 2026, is attached hereto as Exhibit A. Oh yes, there are 2 exhibits, great. On June 29th, 2026, plaintiff finally agreed to dismiss the 8th cause of action for defamation and the Doe defendants by no later than July 10th, 2026. A true and correct copy of an email from my partner Kim Zeldin to Christina Yarnell and Kristen Thaler, dated June 29th, 2026, is attached hereto as Exhibit B. Although Ms. Zeldin and Mr. Kaltgrad followed up several times with plaintiff's counsels, the agreed dismissal was not forthcoming. The explanation given was that they were busy with other matters. I declare under penalty of perjury that the foregoing is true and correct. Okay. Exhibit A. Do I need to go to the bottom? Bear with, sorry. Are these separate? Yeah, okay. Alright, so this is from Amir Kaltgrad, who is Wayfarer's attorney, was Wayfarer's attorney, to Stephanie Jones's attorneys. On March 26th, 2026, the court denied plaintiff's motion to amend their complaint, leaving plaintiff's 8th cause of action for defamation regarding the 2 websites asserted solely against Doe defendants. Please confirm by close of business on April 15th, 2026 that plaintiffs will dismiss their 8th cause of action given that they have not served any Doe defendant and the court has denied their request to amend. Absent your confirmation, defendants intend to file a motion to dismiss the action against the Doe defendants pursuant to Federal Rule of Civil Procedure 4M. In addition, because plaintiffs have no claim against any named defendant related to the websites, the expert opinions of Brian Horton and Joanne Colleen are irrelevant to this action. Please confirm by close of business on April 15th, 2026 that plaintiffs will withdraw the expert reports of Mr. Horton and Ms. Colleen. If plaintiffs refuse to withdraw these expert reports, please let us know when you are available to meet and confer on a motion to exclude both experts and for defendants' costs in taking unnecessary expert depositions. As to Mr. Diaz, I don't know if I'm saying that right, and Jonesworks 30B6 witness on February 17th, 2026, following the court's order extending the expert deposition deadline to April 30th, you told us you would revert with our witness availability. You have not done so in the intervening 6 weeks. Defendants are amenable to jointly seeking an extension to the end of July for expert depositions, which they have done. If you are not amenable, or in case the court does not grant an extension, please immediately provide us with dates next week when Mr. Diaz and a 30B6 witness will be available. If you refuse to withdraw Mr. Horton and Ms. Colleen, please also immediately provide deposition dates for those witnesses. Defendants reserve the right to unilaterally notice the depositions given plaintiffs' failure to provide available deposition dates since February 17th. Oof. Okay, so that was Exhibit A. Here's Exhibit B. They finally got a response 2 months later from Kim Zeldin, Christina and Kristen. This will confirm our conversation today. Jones and Jonesworks will, by no later than July 10th, dismiss the 8th claim and all Doe defendants. In addition, I asked you to look at your pleading and dismiss claims to which Jones is not a party, for example, the contract with Wayfarer. 2. We will send, what is going on with the spelling in this? We will send out the deposition notice for Diaz today. 3. Tentative schedule, 21st of July, Diaz, 23rd of July, Killian, 24th of July, Wagner. All in Los Angeles. You will confirm Killian's availability and we will confirm Wagner's. Hold on. Yes, from Kim Zeldin, right, okay. 4. Horton, followed by Ziedman. During the first week of August, you will let me know when Horton is available in Los Angeles or otherwise, and we can schedule Ziedman, who is in Palo Alto. But I can ask him to come to Los Angeles. Spelling is atrocious here. But I can ask him to come to Los Angeles. I will draft a stipulation to extend the time to take Horton and Ziedman by a week. You'll have it by the end of the week. If you're wondering why I'm banging on about the spelling, it's because much better is expected from attorneys. Spelling, like over in the UK, I've seen people, trainees predominantly, lose their job over, spelling or grammatical errors because, an apostrophe or a comma in the wrong place can change the entire meaning of, a contract. And it's just to look, professional as well. I mean, the amount of spelling mistakes here in this, just this one email, is annoying me. It's just annoying me. Anyway, is this before or after? Right, so this is the reply email. Okay, so this is the first one. Christina and Kristen, this will confirm our... Is this the same one? Yeah. Christina and Kristen, this will confirm our conversation today on Friday, June 26th at 11 a.m. Pacific time. We will have another call, at which point you will be prepared to discuss the issues set forth in Amir's emails of several months ago. They acknowledged the email was several months ago. Hold on, who is this from? Oh, this is from Friedman. Right. Okay, now I'm with it. Right. Okay, so this is, sorry, Right, so this is the first email from Kim Zeldin, who works for Friedman's Firms. Okay, so he's saying, right, we're going to have she's saying, we will have a conversation where we will discuss, basically the motion to dismiss, the what they're going to do with the experts, etc., etc. And then she has followed up. Then they've had a conversation by phone, I'm guessing, or Teams meeting, and then she has done something which is kind of important, really, which is, to follow up in writing, just to make verbatim notes of this is what we agreed. Yeah. So there is a written record, and it's a good job she did, because now here she is, she's relying on it for the motion, and say, well, right, okay, we had a conversation today. This is what we agreed. You said you were going to do this by July 10th. And they haven't done it. And had she not had this in writing, a follow-up, to say, here's a record of what we discussed and what you agreed to do by when you agreed to do it, then she would have been really stuck for, any kind of record that Jonesworks had agreed to do anything. So there we go. That's basically what that is. Right, okay. So that's a declaration. Oh yes, Judge Lyman's order. Right, we'll quickly do that because it's very short, so there's no point me doing a separate video for it. Also, I've just checked because I did, like I said in my last video, I think, or it might have been earlier this one, but I had a status conference scheduled for today in my phone, which in my head I'm pretty sure the parties actually clarified was cancelled because of the scheduling order that had been agreed. I've just checked, and yes, it is cancelled. So that's that. So final thing to get to now is this order from Judge Lyman on the sealing. Very simple, very straightforward. I'm sure everyone can guess what I'm about to say. But he's denied all of Wayfarer's requests. Okay, so there's quite a few documents that Wayfarer has said, can we just seal this, please? In response to the court's order of August 8th, 2026, the parties have submitted letters concerning what information, if any, requires sealing. Continued sealing, sorry. And the parties' renewed requests are narrowly tailored. Stephanie Jones and Jonesworks have indicated that they do not require any continued sealing pertaining to their motions at these dockets. Wayfarer, Justin Baldoni, Melissa Nathan, and Jennifer Abel have asked to seal attachments to certain dockets. As a footnote, the Wayfarer defendants did not identify which sealing motions their letter pertains to, and instead wrote that they moved to seal portions of certain exhibits. The court has determined that their letter bears on attachments and exhibits that were subject to already pending motions for sealing. And that docket number 170, Exhibit 2, is a cover sheet for an exhibit filed under seal as docket number 168, Attachment 2. Additionally, the court notes that neither party specifically mentioned the motions to seal these dockets. The parties have therefore waived those prior sealing requests. Accordingly, the court hereby orders as follows: that the motions pending docket numbers 128, 157, 162, 165, 175, 181, 183, 185, 190, 202, 204, 207, 208, 215, and 222 are denied. The parties are ordered to file on the public docket by August 24th versions of previously sealed filings with redactions for personally identifying information and other sensitive information consistent with the court's orders in Lively. So we are going to get unsealing. It's not going to be like the great unsealing that happened in Lively. These are just going to be a few a few items basically, but we have an unsealing nonetheless that we get to go over on the 24th of August. So mark that in your calendar, people. And we'll see. I want to see as well what Jonesworks come back to with the motion to dismiss. I really can't see how they can argue it, but if they do, I'll be interested. They might just file a brief response to say we've got no objections, you know, so on and so forth. They might ignore it entirely and just let Judge Lyman make a decision, which, again, as I said at the start, I think he'll grant it. I do, because that defamation claim is well out of time, and because he denied Jonesworks their request to amend their complaint to add Melissa Nathan as to substitute her for one of the John Does. So I don't see why he would, you know, deny the motion and keep the cause of action and the John Does on his docket. If he does, that order I really do want to read, just to get the rationale behind it, but I don't think he will. All right, guys. I still have to do Sarowitz and the Celeste Smith. I keep saying it every video, and then I get distracted because it's school holidays and I've got the little ones at home and stuff. So I am going to get to it, though. I intend to get to it today. If not today, definitely tomorrow. All right, guys. Thanks for listening.